Hello everyone, welcome back to my channel. This is Harjita Pishe here. Today I'm here with a new video. This video is a very important video because I've been getting a request by many students who call me, take my number from YouTube and ask me for maybe how to write your exams, or whenever I assist them, the first question they ask me is, ma'am, how much do I write in the question paper? And should I write very lengthy answers, or should I write the answers at point, or what is the pattern of me writing the answers? So for that I have I'm filming this video. Basically I will take I will take an example of a question, and with that example of a question I will be helping you out, and I will be telling you how you can explain that particular question, or how you can write the answer for that particular question. Now, coming to law exams, we've always heard that if you write very lengthier answers and if you elaborate your answers with section numbers, case studies, and other things, you get a lot of marks. That is not very true. If you write your answers aptly, that is more than enough. Definitely, it should be lengthier. You need to write the case studies. I will come up with 2 questions and 2 examples, so that will help you out to understand, is this the way you can write the answers. Now, coming to the first question, I have picked a question from Contract Act 1872 because I felt this would be a little easier for you all to explain. So there is a very important question which is said to be, what is a contract? Explain the essential features of a contract. Okay, so what is contract? Explain the essential features of a contract. Firstly, define contract is exactly what I'm trying to tell. Define contract and explain the essential features of a contract. So firstly, when we are coming to the definition, you need to write the section number. Okay, so firstly, whenever you're defining, I will just tell you what is the definition. According to section 2 subsection H, a contract can be defined as an agreement which is enforceable by law. Okay, so this one single point if you write, I think you will get some marks there. Okay, so there is a section number which is which you can precisely write. Okay, according to section 2 subsection H, if an agreement is enforceable by law, then it is said to be a contract. Okay, so that is the first point you can write. Then coming to the essential features of the contract, the next the answer, or the next the next part of the question would be, what is the essential features of a contract? So the essential features of a contract are as follows. Okay, you can write that, and you can write the essential features of a contract. Okay, that what are the essential features of a contract? See, firstly we have offer and acceptance with an intention to create a contract. Okay, so there is an offer and acceptance with an intention to create a contract. There is consideration, there is free consent, there is capacity to enter into a contract, and there is a legality. Okay, so these are the various essential features. Okay, offer and acceptance with an intention to create contract, consideration, free consent, capacity to enter, and legality of an object. Okay, so the first thing is offer and acceptance with an intention to create a contract. Okay, so see, firstly, if you need to create a contract, there must be a legal commitment that you will be creating a contract. Okay, there must be a legal commitment between two parties. Okay, so only one two parties, if one party is giving an offer and the other party is accepting that contract with a legality, then it's said to be a contract. Then you can tell that they are capable, or they have entered into a contract. So one person is giving an offer, other person is accepting that offer. Okay, so there is an intention between both to create a contract. So here you have two parties, so you can first write that point and you can explain that point. The next thing is consideration. Definitely without any consideration there will be no contract. Okay, so consideration is an essential element of a contract, and means something in written and should result in benefit to the party. So there are two people first who are into an agreement. So one person agrees to something, to do something, only when a person gives him the benefit, or he gives him a consideration, or he gives him an amount of money. So that is when this particular contract will come into picture. So when consideration is being given, it's more legal because you are giving him a price back to the contract. So that is the second point. You can write the points Then you have free consent. See, whenever, what is free consent is, you don't have to, a person will, give his will, or he will give his wish, okay, to the contract, or he will enter into the agreement without any force, without any fraud, without any coercion. You are not going to, dishonestly push him, or you're not going to force him to enter into this contract. He is entering with his free consent and without anyone's force. That time it is said to be a free consent by the parties. Okay, so that is one thing. And capacity to enter into a contract, that is, he must be of a sound mind, he must be a majority person. You cannot allow a minority person to enter into a contract. A minor is not allowed to enter into a contract. Only when he is of a majority age, he can be entered into a contract. Correct? So that is one important thing. And legality of object, that is, the agreement must be lawful, it should not be illegal. You are not entering into a contract for an illegal object, you are entering into contract for a legal object. Okay, so all these are some things. See, in between, now, like I said, there are a lot of points, but for offer and acceptance, there is one illustration which I will say you. You can, write such illustrations only for offer and acceptance. I would say you this illustration. A husband agreed to pay his wife an amount of maintenance every month while his wife had to stay back abroad due to health reasons. The husband paid for some time but later failed to pay the promised amount. His wife then sued him for the recovery of the promised amount. The husband was not held liable as there was no intention to create any legal relationship. Obviously, see, here what is the illustration is, a husband is agreeing to pay a certain amount as maintenance to his wife every month. Okay, but what happens is she stays abroad. Okay, there is no previous agreement here, there is no previous agreement, or there is no any court order. Like, we have under Hindu Marriage Act, we have the maintenance. There is no such things where, there is an agreement between both a husband and wife that there must be a consideration or a monthly pay given to the wife. No, nothing like that. So here it is definitely not a legal thing. It doesn't, the husband, stops paying her, and when she sues him in the court, it doesn't, create a legal relationship, or it is not a legal agreement, because here there was no agreement. It's just a word of mouth that he has told, I will give you some money to maintain yourself, but there's no agreement as such, which shows that he is, very sure that he will pay her. So this doesn't create any legal relationship. So like that, we can, write an illustration for every point, like for offer and acceptance, for consideration, for free consent. Okay, so there are certain illustrations, or you can give certain examples. Okay, this comes in the case of contract, because this is Contract Act 1872. This comes in the case of contract. Now coming to certain law subjects, like we have criminal law. I have told you about criminal conspiracy. Or you, for example, take this section number, you take the section called rape. Now if you're taking the section rape, you first need to write according to what section, rape is being defined, and what is the punishment for rape. And also you can also give, the important case studies under it, that, you have the famous Nirbaya's case, or whatever case studies are there, you can give those case studies, which will help you out. Okay, and then you have criminal conspiracy 120A, 120B. Or if you're going with murder, what is murder according to section 304? What is murder? What is culpable homicide? Now culpable homicide is also said to be a murder. It's 299, and then you have 300. I think, yeah, 300 is murder. So what is murder? What is the definition of murder? Do you have any case study under it? Do you have any illustrations under it? According to section 300, murder can be defined as follows. According to section 299, culpable homicide can be defined follows. Let me, just confirm it once, because as much as I know, the murder would come under, yeah, correct. So culpable homicide and murder is section 299 and 300. So you can just write that according to this section number, this is being defined. That is, the murder is being defined, and this is the definition of murder, and also this is the definition of culpable homicide. Okay, and you have certain illustrations. Okay, so the illustrations are the ones which will explain what is culpable homicide. Okay, and when you go to murder also, you have certain illustrations. Always try to write your illustrations, which will help you out. And then if you have a case study, you can also write the case study. See here, the leading case study in the culpable homicide is KM Nanavati versus state of Maharashtra. So now this is a very important case. There was a movie also out for this particular case. So this particular case you can, elaborate. So for each answer, try to read one case study, or try to keep an importance of one case study, so that you can elaborate. Like now I told section 376, you have rape, that is, it defines rape. So you have a lot of cases like Mathura versus state of Maharashtra, you have Nirbhaya's case. So you can expand and you can write that case. Now coming to 299 and 300, I told 299 and 300 for murder and culpable homicide. First define what is murder, first define what is culpable homicide, then write the illustrations, and then come to the case study. Like I said, for culpable homicide, KM Nanavati versus state of Maharashtra is the case study. So you can write the points, the facts of the case, and what was the main judgment. Okay, so that is the main thing, like what we are expecting, what they expect, not me, what they expect for you to write in the question paper. Like previously also I have done some videos on the case studies. Bhopal disaster, MC Mehta versus Union of India Bhopal disaster leakage case. So you first need to write the facts of the case, and then what, see in that particular case, if you see the, there was a, methyl isocyanate gas was leaked, and because of that a lot of people were injured. And when they were injured, immediately, they were taken, or they were hospitalized, many people were killed. And because of that, this particular industry was sued, and they asked for compensation. And first it went to the New York court. It was dismissed because it was not filed under the jurisdiction, and then it came to Indian court. And then first it went to, the civil court, then it went to the high court, and then ultimately it went to the Supreme Court, where a, amount of compensation was decided by all the three courts. And then an order of compensation, the compensation amount was given. So that is how you need to write. Okay, so each and every case study will have the facts of the case as to what happened in that case, and then what is the judgment by the court. Okay, so that is the reason we always, we keep telling, that case studies are very important. I don't know how many people follow, or how many people, when you are reading your law exams, for your law exams, how many people do follow, read case studies, I don't know. But it is very important, guys, believe me. If you're coming to practice also, it is equally important, because tomorrow when you are going to file each and every application in the court of law, you are going to cite a case. So we have something called a citation of case. Since now all the law students are studying, you have case studies, but when you come to practice, you need to cite each and every case, each and every point. So now I cannot just go file an application. Like for an exemption of an application also, there will be an argument. After each application, there will be an hearing for the case, for which we need to give a reference of the case study. So it is very important for you all to go through case studies. Please give importance to case studies. Please give importance to section numbers and illustrations. If you write it this way, then I think it would not be a difficult task. So this was it for today. So I hope you understood. So there are certain, recommendations what I told as to how you need to write your KSLU papers. First, elaborate the definitions, write the section numbers according to what section number that particular thing is defined. And then after that, if you have illustrations, write the illustrations, explain it. And then, if you have exceptions, write the exceptions, and then come to the case studies. So if you write the case studies at that point of time, haram se, I think 1.5 to 2.5 pages, you can, haram se write your answers. So it will be more helpful for the evaluator, so that he will think that you know something at least. Okay, so this was it for today's paper. See, this is just, the knowledge, what the way I have studied, the way I have written my exams. So I hope this is helpful for you all. This was a very recommended video. They used to ask me always, ma'am, I'm writing lengthier answers, but I'm writing pages together, but I'm not scoring marks. So excuse me, how do I write? So this is all for today's video. If you like this video, please to press the like button, and please to share. Thank you.